All right. I'm going to give everybody just a moment to get all logged in, but I hope everyone is having a wonderful day. We are so excited to have you with us. I think everyone already knows who I am. My name is Ginger. I'm the Executive Director of the Connectionology Seminars of America and also webinars. And we are so excited to have you today for our first part one of a series that we're developing on Daubert. So it's going to be wonderful. I know there's going to be a lot of questions and we want this to be interactive. Go ahead and feel free to put your questions in the chat box or the Q&A box, and both John and I will be kind of monitoring that. I really want to do a special thanks to our two amazing partners with HMR and OnPoint. Later in this webinar, you're going to be able to meet both of them, and I want to thank everybody for supporting all the great work that they do. I also want to thank everybody for watching. So we're going to have a really good time. And let's go ahead and get started because I know we're going to have a lot to talk about today. I'd like to first just introduce all of you to our amazing moderator, Mr. John Romano, who's the founder of the Romano Law Group in beautiful West Palm Beach, Florida. A neat fact about John is actually before he became one of America's most beloved trial lawyers, is he was actually a captain in the United States Marine Corps. And what's even better is that John and Mike actually go way back, you guys. We're talking about into like the 70s. So they know each other, they've been friends, and I can't wait for them to share a little bit more about that. But also John is board certified. He's gone to trial in just about every single type of civil and criminal case that you can imagine. And he was also inducted in the Trial Lawyers Hall of Fame in 2016. And he's also an author. He's one of the most sought after speakers. He's been the president of the Melvin Belli Society, the Southern Trial Lawyers Association, the Florida Justice Association, as well as the National Trial Lawyers. But we all know that at home, Mr. Romano is actually considered the vice president because the president is Miss Nancy Romano. They've been married for over 51 years and they have 11 beautiful caring children. And John, we are so proud of you and all the work that you do for your clients and for your firm and for all of us watching today. So thank you for being with us, and I'm looking forward to this.
Ginger, thank you very much. And I want everybody to make sure you're thinking about Ginger and you thank her for all that happens, because that's not only before COVID, but once COVID hit, Ginger is the one responsible for putting all of these extraordinary webinars together. And then we got all these seminars. We're coming back to the live seminars, but when we're all doing our other things, Ginger is working to put these programs together for us. So thank you for your dedication and being everything that you are and always being so uplifting to everybody. It's just wonderful that you're a part of this, Ginger. I am beyond excited about today because I get to bring to you someone I have not only known, have I known Mike for the better part of about 50 or so years. We actually met way back at Camp Lejeune in the United States Marine Corps. And I'm going to tell you a little bit about Mike because you're about to hear not only from one of the greatest lawyers in America, but from one of the 3 or 4 people that I consider to be the most analytical, inquisitive learners, evaluators, assessors of issues like no other lawyers I've ever known. Mike started out, finishes up high school in Pensacola, Florida, and then goes off to Georgetown University up in Washington, D.C. After that, he goes into the Marine Corps. And Mike ultimately became a captain in the Marine Corps, but he was an infantry officer primarily for the better part of 6 or 7 years. And then guess what he does? He applies for a position to be a non-lawyer prosecutor in the JAG office, which is where I met him back in the mid-70s. And he quickly becomes the single best person in the courtroom, including all of the lawyers. And I just remember thinking, with somebody that skilled and that talented, I hope to God he goes to law school, which he did. And he went down and ultimately graduated from the University of Florida Law School, then went into private practice. He has gone to verdict in virtually every kind of case imaginable: product liability, medical malpractice, wrongful death, admiralty, maritime, aviation, toxic tort, civil rights, wrong employment, everything. But if you go back to the 1980s, Mike got very involved in the Dalcon Shield, Lippy's Loop, Tatum T, IUD cases, and really was one of the litigation and trial pioneers in those cases. And that was before there were really MDLs and steering committees set up. And what he did was just extraordinary in helping the team of lawyers from around the country prevail in that litigation ultimately. And Mike was one of the lawyers responsible for finding, locating, and ultimately deposing two of the whistleblowers in that litigation, which really turned everything on its head. He's not only a trial guru, he's a discovery guru. Again, there are a few lawyers I can count on one hand who they're from another planet when they take depositions. One of them is Mike Eriksen. The way he analyzes the issue, the way that he prepares, I've never seen anything like it. It is extraordinary. And that doesn't matter whether it's an eyewitness to someone who's on a cruise ship and they go off on an excursion and they're eyewitnesses to the incident, or it could be someone in a malpractice case, or it could be a 30B6 witness in a deposition in a case pending in federal court. A few years ago, well, actually many years ago now, probably about 15 or more years ago, Mike moved into really doing a lot of cases in admiralty and maritime. And that has become a true specialty niche for him, where he has done not only sexual assault cases where there is a sexual assault by crew members on individuals who are passengers on the ship. He handles major cases involving injuries on the ship, but a real specialty area has been where the ship sets you out, get off the ship, and you go off on an excursion, and you are injured off somewhere on an island. And most lawyers I know, they think those are impossible cases. Mike turns them into gold because he works and he works and he works. And the way he prepares them, it is just magic. He also is one of the true masters in America when it comes to handling the Daubert motions, not only affirmatively, but defending against them. And he knows everything about the law, the strategy, the tactics, and that's what he's going to talk to us about. The best thing I can tell you about him, though, anybody who knows Mike will tell you, as intense as he is as a trial lawyer, you cannot find anybody who is more kind, generous, caring, and giving. And he has been married to an awfully long time to a wonderful lady, his wife, Carrie, and they have been blessed with 4 amazing kids, Casey, Ryan, Caitlin, and Mary Kate, and they have grandchildren now. This is one extraordinary human being, one extraordinary lawyer, and I am really proud to bring Mike Eriksen to all of you. Mike, the floor is yours.
Okay. Well, can you all hear me okay? How's my audio?
Yes. Audio's good. Audio's good.
All right, this is my house. That thing you see in the back is for show. It's an elliptical. This is my first webinar, but if you'd seen the same scene about 6 months ago, the handles would have been in the same place. John, that was awfully generous of you. And John is sometimes given to hyperbole. I'm speechless. I would say you can take, except for my family, you can take everything that John said and probably divide it by 5 and be a little closer to the truth. John was correct that I was a grunt in the Marine Corps, and I've kind of been a grunt in the legal profession for the last 40 years. I've pretty much done all my own cases. Nothing as flashy as John is suggesting, but a lot of grunt work. I was going to have a PowerPoint today, but I thought what we do instead is kind of have what I'll call a group therapy session on Daubert. And I'll say I'm definitely available for individual one-on-one therapy. I'd like to give you all my cell phone right now, and I'll give you my email address. I don't have it up on the screen, but my cell phone is 561-644-2875. And my email address is the initials M as in Mike, D as in David, E as in Eriksen, at Travelaw, TRAVELAW.com. It's just one L, the word travel with an AW on the end of it. So it's MDE at Travelaw.com. And feel free to email me, or you can call me on my cell phone at any time. And I've got a lot of examples of some of the things that we'll talk about today, like Daubert-Briefs and expert reports and things of that nature. And I'm happy to share those with you. I'm happy to spend time with you on the phone and talk about your individual case and what I might be able to do to be helpful. I never really, I don't claim to be a guru of any type. John, again, is being very generous. And I, like most things in life, I learned about Daubert the hard way. Okay. Down here in Florida, the personal injury lawyers that have probably had the longest exposure to Daubert are those small group of us that handle cases against the cruise industry. The cruise lines have forum clauses in their federal forum clauses in their tickets. So all those cases have been in federal court for the last 15 years or so. And Daubert has been alive and well in federal court forever. So we got a kind of a personal injury lawyer's first taste of those Daubert issues that come up. Our Florida state court system only recently adopted Daubert as opposed to Fry as the kind of the rule of decision when it comes to expert witnesses. And I told you I learned some of my lessons the hard way. A long time ago, I had a cruise line case, and I won't tell you which one, but basically it was a pretty serious injury case. It was a quadriplegia case and against one of the major cruise lines. And I had 4 experts, and I went to the defendant's depositions of those experts, and the defense lawyer started asking things like, well, what was your methodology to get to your conclusion? And I'm sitting there thinking, what in the hell is he talking about? I had no clue. I don't think I'd even heard of Daubert at that point. And so I got Daubert motions directed to my 4 experts. I lost 3 of them. Now, luckily, the one that was left was, able to get us across the finish line. But I resolved at that time that I would get pretty familiar with Daubert and hopefully never lose another major Daubert motion. And I don't think I have since. It's been a long time. But I sure started out, pretty rough at the beginning. And again, that's probably everybody's experience here. We all kind of learn things the hard way. I have to get hit over the head with a baseball bat a lot of times to figure out certain things. So that case was no exception. Let's talk about just a minute about, what is Daubert? I mean, what the heck does it mean? It's Daubert, D-A-U-B-E-R-T. It's a Supreme Court case, but it's also a way for judges to screen expert witnesses and keep the wheat and throw out the chaff. That's the way it's supposed to work. It doesn't always work that way, but it certainly does sometimes. And depending on the mood of the judge, state or federal, that's handling the matter. Starting with the federal court system, and I'm not sure how many of you guys and gals out there spend a lot of time in federal court. I happen to, just because I do maritime cases somewhat. And I don't know who in the audience is a criminal lawyer as opposed to a personal injury lawyer. I think as it relates to criminal and personal injury, I haven't seen a lot of real differences in the way Daubert is applied. I think that the primary difference that I've seen between federal court and state court is that the federal judges have resources in the form of law clerks and assigned magistrates and a significantly reduced caseload in comparison to a state trial judge, that the federal system is able to really apply Daubert in a very articulate and a microscopic way that you just don't typically get in state court. Florida, as I said, recently adopted Daubert, and frankly, I'm not positive that Daubert and the type of effort and time and so forth that has to go into Daubert is a particularly good fit for our state court system, because you got, state trial judges, we call them circuit judges down here, and they may be handling 1,500 cases on their docket at any given time, and they just don't have a lot of time to devote to Daubert issues like the federal judiciary does. And so another aspect of our state court system down here is that the state judges pretty much have to decide everything on a face-to-face hearing basis. You actually have to go in front of the trial judges in state court down here, whereas in federal court, they have the ability to decide Daubert motions based on the papers. Some federal judges will have formal Daubert hearings. Since COVID, we've been doing them a lot by Zoom, which is a good thing. But even Zoom hearings and spending a lot of time reading papers and making decisions on papers is actually beyond the capability of our state judges down here. But what is Daubert? What the heck does it mean? It basically is a system that gets applied with certain criteria to an expert witness by a judge who basically decides whether or not that expert's testimony in the form of opinions is going to be allowed in the jury trial or in a bench trial for that matter. And they basically have a criteria. The relevant federal rule of procedure, or I'm sorry, of evidence is Rule 702. And basically there are three things or three hoops or three hurdles that an expert witness has to get over under Rule 702 in the federal court system, and also under our state version of 702 now that Daubert has been adopted. Basically, and I'm kind of getting them out of order, but the first one of the requirements is that the expert's proposed opinion testimony, it's got to be helpful to a jury. In other words, it's got to be something that the jury can't figure out on their own. And that's been a problem for some of the judges down here. For example, and there's a federal judge who's a senior judge in the Southern District of Florida. I'm certainly not going to name him, but over time, he's formed the belief that at least on the liability aspects of a personal injury case, and particularly the classic case that you see on a cruise ship, which is a slip and fall or a trip and fall, that there's really no place for expert testimony. He's of the belief, and has been, that there's nothing about a slip and fall or a trip and fall that a jury can not figure out on their own. Whereas in reality, the cases have gotten so sophisticated down there, even those types of garden variety personal injury cases where you've got to have expert witnesses to go out and do slip resistance testing on the deck where the slip happened, or you have to have an engineer go out and look at the location where the trip happened and take measurements and so forth and apply what they see to independent, non-binding safety standards that might be out there. And all of that stuff is clearly not within, that type of stuff is not within the ken of a typical layperson, unless they happen to be an engineer. But this particular judge doesn't believe that, and every Daubert motion against a plaintiff's expert in a case like that is successful. Typically, they have to get appealed, and typically they get reversed on appeal. The general rule is, or the general feeling among the judiciary, at least in the Southern District of Florida, is that those are the types of subjects that are beyond the recognition of a typical jury, and an expert ought to be allowed to testify because that testimony is going to be helpful to the jury. The other, again, I kind of got the cart before the horse. The first criteria of Daubert is that the expert has to be qualified. And we're going to get in a minute to the, how do you prepare your expert? And I'm going to advocate that you start preparing your expert for a Daubert motion when you make a decision to take the case. I mean, it goes back that far. But the qualification aspect is you got to get an expert who is a really good fit for the particular case that you've got. And I'll give you an example, a case I've got going right now, which is kind of it's a weird case. It happened on a cruise ship where a passenger walked in, was up in the spa of the cruise ship, and there was what they called it a snow room. It was like a cold area of the spa, where a small room where they made artificial snow. And he walks in there and basically there's ice on the floor, and he slips on the ice right inside the door, and he breaks his hip, and it's a pretty bad injury case. And so, what kind of expert do you want to go find for some case like that? Mindful of Daubert and mindful of the microscope you're going to get over the expert's qualifications in federal court. Well, I mean, your first reaction is, first off, if you're living in Florida, there's not a lot of snow and ice down here. So, I mean, Florida is not the place you're going to go to look for an expert in a case like this. And so you start looking around, and you're hoping to find somebody who's at least knows enough about snow and ice to be able to analyze that situation. And sometimes you can't find people, particularly in the U.S. And the expert that I was able to find after a lot of work on this was a gentleman in the U.K., which seems to be a kind of a focal point for these artificial indoor snow facilities that you've heard about, like up in New York at the Meadowlands, where they have Abu Dhabi and other places. Well, his company specifically has been involved in all that. I found out that he had gotten a U.S. patent in an indoor snowmaking technology, procedure, or process. So I figured that guy is probably going to be somebody who's going to be relatively impervious to an attack on his lack of qualifications. I think one of the effects of Daubert, and I would say this probably applies to every scientific and medical field, is that the days of your general all-purpose safety expert, let's say on liability, I think those people are dinosaurs. And I think it's what those types of people used to be able to do under the Fry system, or what we as lawyers used to be able to do with those types of general experts under the Fry system, is to give them a bunch of stuff. And first off, I was guilty of this just like everybody else. You want to delegate stuff. If you're a busy trial lawyer, you don't want to have your finger in every single detailed pie. John Romano is one of the best delegators I've ever met, and he's very successful at it. And I think his practice and the success of his practice shows that. Me, not so much. I'm a micromanager, and so you want to. Back in the day, the pre-Daubert days in our state court system, what you'd want to do is you'd want to get a paralegal or somebody to gather up all of the stuff. Now, what's the stuff? It's the depositions, it's the medical records if it's some kind of a medical expert, interrogatory answers, the complaint. I'm not sure what that helps an expert do. And you send them a big pile of stuff. Like it'll be, sometimes a stack of stuff will be like, 6 inches or 12 inches high. And then, comes time for their trial testimony. You bring them into court and you go, okay, what's your name? Well, John Brown. What do you do? I'm an expert. What did you do in this case? Well, I reviewed this big pile of stuff. Well, what's your opinion? Well, the defendant screwed up, or the other side screwed up. Well, what's the basis of your opinion? Well, I'm an expert. You can't get away. The Daubert is specifically designed to wipe out that type of testimony. And when an expert comes in and says, well, this is my conclusion, and you ought to believe it because I'm an expert. That's what there's a Latin term for that called ipsa dixit. And basically, I think that stands for because I said so. That is absolutely what Daubert, the primary purpose of Daubert is to eliminate that type of testimony. So you can't get by just with a qualified witness as you could under Fry. Under Fry, all you had to do was to prove that the expert was generally qualified in the area of the proposed testimony. That'd be enough, and they could say anything they wanted to after that. Not under Daubert, which leads me to the third criteria under Daubert, which is perhaps the most important. It is the most important, and that is the methodology requirement. Okay, it's the person has to. And I had an associate. John and I both had an associate. We used to be partners on top of blood brothers and former Marines and everything. But John and I were together, practicing law together for years. And we had an associate named Dustin Herman, who I remember listening to and giving a Daubert speech somewhat like this one. And he said the methodology requirement basically requires the expert to, quote, show their work, end quote. And I'm sitting there thinking, what the hell does that mean? Well, and the analogy or the example he gave is like the the middle school math student that goes up to the blackboard And it's not sufficient just to write the answer down. Okay, that's analogous to this Fry expert that says, why should we accept your conclusion because I'm an expert? Well, that's not enough under Daubert. What you have to do is you have to show the 2 + 2 + 2 part before you put the 6 down. And as long as the expert does that, you're going to be in pretty good shape under Daubert. But it gets back to the selection of the expert. You have to select an expert that knows the formula. And a lot of these generalists just don't know the formula to get to the answer that you require for your case. So let's talk about I know this presentation is about how to get your expert ready, and I'll get to that. I keep saying I'm going to get to it, and I will in a minute. But let's just talk about some other troublesome aspects of Daubert. Every jurisdiction that I've ever dealt with in relation to Daubert has the following effect or procedural outcome, and that is a party making a Daubert motion against the opposing party's expert almost by just saying Daubert, case style, plaintiff's Daubert motion, defendant's Daubert motion, and then almost all they got to say after that is just Daubert. It's like it's like that. The phrase that comes to mind, I don't know if any of you guys have ever seen that Young Frankenstein movie, but it's awesome with Mel Brooks. And there's a scene in there where you got Frau Blucher, and every time somebody says the word Blucher, the horse neighs. Well, it's almost like that with Daubert. Just by saying the word Daubert, what the proponent, or what the moving party does is able to shift the entire burden of going forward with proving up your expert and showing that he or she is qualified, shifts it over to the non-moving party. So at that point, you got to lay out why your expert is qualified, why they've got a sound, reliable methodology to get to their conclusions, and why what they're going to conclude or what they're going to testify to is helpful. And only then does the moving party have to come back and rebut that in some way. So it's and the other aspect of Daubert is that basically the standard, the judicial standard that applies to the resolution of a Daubert motion is an abuse of discretion standard. And so if you lose it, let's say you're a plaintiff and you got what I call an expert heavy case, which means you got one or more of your major elements in your case relies, maybe not exclusively on expert testimony, but a lot on expert testimony. And if the judge, Dauberts your expert, takes your expert off the board, then what have you got left? And oftentimes the answer is nothing, which oftentimes results in the Daubert ruling being followed by a summary judgment ruling. And then when that gets taken up on appeal, when you're appealing the summary, ordinarily back in the old days, when you appeal the summary judgment, the appellate court was required to review that on a de novo basis, which means we're going to look at everything fresh. But if it's the type of summary judgment that's based on the Daubertizing of an expert or the taking away of an expert under Daubert, then the standard of review on appeal is abuse of discretion. And that's just awful. Okay. So, what's the moral to that story? I always say, I want to get back to the case intake, point where somebody's sitting across your desk and they're telling you what happened and you're trying to figure out, who can I sue and do I want to take this case? You need to be asking yourself the question, how much of this case is expert heavy? Okay. How much of it? And the reason you need to ask that question is because it can produce some consequences down the road when you start having to deal with Daubert motions on your expert. So you want to be careful about the type of case you take. And, some cases are expert heavy, but then, however, as an alternative to, each element, depending on an expert, oftentimes you got some backup fact testimony that will get you across the finish line on a summary judgment motion, even if the expert on that same element is taken out. So you need to be thinking in those terms too. It's a very common federal judicial tactic down here in in Florida at least, to wipe out an expert on Daubert and then grant a summary judgment. That happens a lot in the Southern District of Florida. I'm sure it happens in the other couple of districts, federal districts in Florida. State court, not so much. And I think, or yet, let me just say yet. In federal court, it's gotten to the point where, down here at least, where every single expert gets a Daubert motion, every one, just whether they got merit to them or not. And that's another problem with getting back to all they have to do to shift the burden of persuasion and proof to the non-moving party is just to say Daubert. That's, it's unfortunate that that's the case, but you basically it leads to a situation where you just have to be really careful about selecting the case at the front end because of that situation. The takeaway, I think, is to try to avoid relying entirely on expert testimony and expert evidence to avoid a summary judgment if you can possibly not do that. The reason why Daubert is, I think the state judges down here, because they don't have a lot of experience with it, and they're going to have to rely a lot on federal case law, for example, and federal precedent before that gets developed in the state court system. A lot of these judges understand, down here at least, that the state court system has recently adopted Daubert in replacement to Frye, but there's still the mindset amongst most of the lawyers that participate in state court cases primarily, and the judges, is still a Frye mindset. They are not going to be as likely as a federal judge, at least down here, to grant a summary judgment for any reason, okay, let alone taking away an expert by Daubert. Let me talk to you about the process. Federal court, at least the federal judges down where I live, typically resolve Daubert motions on the papers. Okay, so you have to be, and I'll get into this in a minute, you have to be mindful about making a really good record, starting with the depositions of your experts. The state court system they're not going to have the resources, at least down here, to do that kind of detail work on a Daubert motion. They certainly are not going to decide on the papers. They're more likely than not to have a kind of a motion type hearing, which is basically going to slow everybody's case up. That's another reason why Daubert is really not a good fit for state court down here, because just the process you have to go through, which takes a lot of time in state court or federal court, you transfer that over to state court, and the judges are going to be overwhelmed, and your case is going to take twice as long to get to the finish line as it would be without Daubert being a factor. I see Ginger on here, so I probably need to shut up for a while.
No, this is great. We're going to take just a really quick, short break, Mike. Okay. And by the way, I see some really wonderful questions coming in. We're going to get to those after I introduce Richard with HMR and then Don with OnPoint. I'm going to bring them in just for a moment so that way they can say hello to everybody and then let them know a little bit more about what they do. So he will be here in just a moment. And I'm going to bring in Don. This is good information.
I hope so. I wish I'd known it before that case I mentioned about. That's for sure.
Exactly. Hey, Richard, how are you doing today?
I'm wonderful. How are you?
I'm so glad that you're with us. We missed you. Thank you for taking the time to just pop in and say hello to everybody. And if you can, tell us a little bit more about what HMR specializes in.
Yeah, absolutely. And thank you for having me. It's always lovely being here and seeing all y'all. So HMR Servicing, we are a national medical funding company. So our bread and butter is catastrophic injuries, and we are a non-recourse firm. So there's no hidden fees or anything like that. We also do pre-settlement funding advances as well. So if your clients need help, paying bills every month, or they have a medical provider that doesn't hold lien or whatnot, we can always advance money for that. And on the subject of Daubert as well, with experts, we are launching a very competitive case cost litigation funding program as well. So we're kind of like the one-stop shop for attorney law for law firms, and all of this non-recourse as well, which is excellent. And I know there's a lot of good reviews and input after someone has used HMR, since we do understand litigation, and we do have inside and outside counsel to help us and you, everyone along the way if you do get into the thick of it in litigation. And we operate in 40 states, so we work with over 1,200 providers. We've done hundreds of law firms cases, so we are very seasoned. We understand. We've been in the business a very long time, and we're just happy to help support Connectionology and all the local CLAs and the national CLEs, as well. And I look forward to seeing any of y'all if you're going to the Western Trial Lawyers Conference or Bob Simon's Bourbon and Proof. Thank you so much for your time.
Richard, great job, and thank you. And I thank you and HMR for your support of Connectionology all the way through this time period with COVID and before. But our firm has worked with HMR in the past, continues to work with you, and we do that because you all do a great job for the clients in trying to assess the needs of the client in order to help get them better, which in turn ends up in the long run helping the case and helping everyone involved in it. So I can't thank you enough for your great work and for staying in there, and great job on your presentation. Thanks.
Thank you, John. Appreciate you.
Absolutely. And Richard, don't forget to put your information in the chat box for everybody so they can stay in touch. Okay.
Okay. Thank you so much.
All right. And then I'm very excited. Ted is going to be popping in at the end for the coffee giveaway. So I can't wait to see who the winner is going to be. But thank you again for everything that you guys do. We love working with you.
It's likewise. Thank you so much.
All right. And now I'm very excited to introduce everybody to Dawn with On Point Legal Nurse Consulting. And Dawn, I think I can see there. We are so happy to have you. And thank you for taking the time to kind of say hello to everybody. But tell us a little bit more about what you guys do over there at On Point.
Well, great to see you and John again today, Ginger. We're a nationwide litigation support team, and it's been so interesting to me listening to Mike because we provide, and we always ask experts about whether they've ever had a Daubert motion or had testimony excluded. So I have a master's in health law, which tells me a little bit about a lot of things. So this has been very, informative for me to have a better understanding of what exactly that means and what the criteria are. But something he said that was really important was he talked about selecting a case and just being careful about selecting the right cases. And when we're looking for experts, until you've made the determination that it is a good case, we know you don't want to dump a ton of money into experts. So we really will try, if there's a question on how strong your case is, to find an expert that'll do kind of a quick down and dirty review and give you a thumbs up or thumbs down so you know if it's even worth proceeding with. And then, of course, if there's merit to the case, then they would do a more in-depth review. But there's not a point in you paying for, 6 or 8 hours of a review if there's not even a case there. And another thing that he mentioned was not finding just garden variety experts. And, he specifically mentioned snow experts and slip and fall experts. And we actually locate those experts, but we also locate nurses and physicians and all the ancillary personnel. And there are so many subspecialties. So if, for instance, you wanted a physical therapist for a nursing home case, then we're not going to send you one that works in a home health setting. So things that are really important to us in helping you find the best experts to make sure that their testimony isn't excluded and that they're qualified to work on your case. So in addition to locating experts, we also can start from start to finish with you to records, organize the records, do timelines, chronology, summaries, and then just help you keep track of your case and make sure your expert does stay on task throughout the course of the case. So we would love the opportunity to talk to you about how we could help you with experts on your cases and also with things like pain and suffering to really drive home the point of what your client went through to make sure that you can maximize.
Well, Dawn, thank you so much. And I can't thank On Point enough for your support and help and all of your involvement with us at Connectionology Seminars of America. I know we, Ginger, myself, Nancy, all of us, we just love working with you. But I want everybody to know this. I have reached that point we don't move forward in cases without having a nurse legal consultant involved in the case. And I'll just give you a couple of examples, but one is what I just call the nurse medical interview, where you have a complicated either medical malpractice case, a toxic tort case, a pharmaceutical case like you get in mass tort cases. Lawyers, we believe that we're the greatest interviewers and interrogators on the planet. Yet we don't cover half of the important things that a nurse covers when a nurse interviews that same client regarding the same set of circumstances, because the nurse comes at it from a totally different mindset and thought process. So we love having the nurse interviews. Another thing that has been wonderful for us has been the on-point pain and suffering reports, where they cull through sometimes thousands of pages of records, put together a report on every aspect of the pain and suffering, not just the complaints, not just the doctor's notes on the pain and suffering, not just the medications, but everything else. And they have been wonderful, especially to use in mediation and to supply to some of our witnesses. So I can't thank you enough. And again, thank you for all you do with Connectionology. Thank you, Dawn.
Appreciate it. Thanks, John.
All right. And then Dawn, don't forget to put your information in the chat box for everybody too, okay?
Thanks, Ginger.
All right. We'll see you soon. Thank you.
Bye.
And now it looks like we have a couple questions.
We do, and I've been looking at them here, Mike. A few questions, and I've culled one of them down into one question. But one is, we have an attendee who would request the contact information for your expert, who is the expert who tests for the slipperiness and the friction testing. And my thought is, rather than broadcast that all over the country, I'm just going to ask that lawyer to please email you privately, and that's mde@travellaw.com.
Yeah, just one L. Somebody asked whether there's two L's in there. In travel law, it's one L, TRAVELAW.
Okay.
And I'm happy to respond to that.
Perfect. And another question, how, Mike, do you get over the waiver provisions that passengers sign prior to boarding a cruise ship?
Well, they don't actually waive any substantive rights. The main features of a cruise ticket are time limits and forum clauses, okay? And the only problem you run into is if you blow the time limits or file a case in the wrong forum, or at least a forum where they can't transfer the case to the right one. So, but as far as any waivers of substantive rights, there really aren't a lot of those in the cruise tickets to worry about.
So let me just interrupt and throw out an example. But let's say I'm an attorney in Arizona, and somebody's been on a cruise ship up in Alaska.
Yeah.
And they come to me and I say, well, gee, the Admiralty statute of limitations that I just looked up says 3 years. And since it happened up near Alaska, that would certainly be the venue. So if I give them that advice and I say, your venue is going to be somewhere in Alaska and you got 3 years before you got to do anything, what have I just done?
Committed legal malpractice. I mean, not to put too fine a point on it, but that's basically what, and I've seen that more often than you might guess, but it's probably the thing to do at that point is just get online and type in cruise lawyer Florida, and you'll get a bunch. Some of them are just kind of pretenders with nice websites, but there's a group of about 15 lawyers down here that handle that type of case on a regular basis. And just call them up and they'll set you straight on that in a hurry. Ultimately, somebody's got to read the ticket. There's a cruise ticket. It used to, when you got a ticket on an airliner or a ship, it'd be a big booklet, hard copy booklet. Now it's online. They have you click through it to acknowledge that it's there, but nobody ever reads it. But if you think about it, you can just type in Carnival cruise ticket, okay? On Google, and the PDF will pop up and you can read it. Same with the other cruise lines. So that's my advice on that one.
Okay, those were the questions. Back to you.
Okay, well, let me just use that request for this slip and fall expert engineer as kind of a platform for a couple of comments. Number one, I mean, this is an expert that I kind of developed from scratch. He was a garden variety mechanical engineer. And I went out and bought him once I found out there's a special piece of equipment that you can use to test a wet deck to see how slippery it is. I bought one of those and basically trained him up and, years ago. And we've been out on ships, and not just ships, but other kind of slip and fall venues to, basically test so that's getting that, and that's a methodology. And I talked about having an expert heavy type of case. I mean, you could call that kind of a case an expert heavy type of case, but if there's also like a subterranean issue of how long was the puddle on the floor, was it on there long enough for the defense to the defendant to pick up on it and do something about it? I mean, that's a secondary approach to that case. I call the how long the puddle was on the floor case. That's a kindergarten approach to slip and falls. What you got to do is attack the flooring, and that's what elevates a garden variety slip and fall, in my mind, up to a high-tech type of case that's going to start costing some money. But if you lose an expert in a case like that, you've got that factual, theory, that how long was it on the floor theory to back it up, so you don't get summaried out in the process. The lady that just talked about, I guess from the expert witness organization, I'm guessing they probably look for to try to find experts who have not been Dauberted or have not been successfully Dauberted. And this particular expert I'm talking about, I mean, I've successfully defended him in at least a dozen Daubert Daubert type motions where they've been denied. And at least down in our jurisdiction in the Southern District of Florida, once they start winning Daubert motions, once an expert starts prevailing, then the subsequent judges start giving them the benefit of the doubt. The reverse is also true. I've seen experts that just get hammered, time after time after time. Sometimes not the expert's fault, but sometimes because the lawyer, that retained them was like I was in that first case I mentioned, and they don't know Daubert from Shinola, and they're not doing a sufficient job to prepare the expert, starting from, like I say, from the time you take the case is when the Daubert process should start. Let me talk to you just a minute about, we talked about, what's a reliable methodology. And, at some point, at least in the federal system, the expert's got to generate a report. That's not true in the Florida state court system. But an expert can certainly, most medical experts generate reports no matter what jurisdiction the case is in, not so much with liability experts. But in federal court, a liability expert has got to generate some type of report. So, what should you be thinking of in terms of what needs to go in that report? First off, you have to realize that a lot of doctors, not so much, but a lot of other types of experts, they're smart, and they know their subject, but they don't write very well. Okay, and if they don't write very well, I mean, who's going to be reading that thing? It's going to be some law review type recent graduate from law school who's a federal law clerk who's all about writing. Okay, and they're going to get pissed off when they see a report from an expert that's incoherent. So, in federal court, at least, the lawyer can't write the report, okay, but you can certainly participate in if you need to revise it or suggest revisions for grammatical clarity, for example, you can certainly do that. And all of that correspondence back and forth and communications on that type of topic between lawyer and expert is privileged under the federal rules, not under our state rules here in Florida. So I'll talk about that topic in a minute. But you need the type of reports you want to get out of let's say a typical liability expert, if there is such a thing. Think of it, what it should look like is a term paper with footnotes, okay? Back in my college days, you could write a term paper and you wouldn't have to footnote or anything. You wouldn't have to reference anything. It's like ipse dixit, because I said so. Sometimes you get a good grade on something like that. But you need to be thinking about backing up everything your expert says with some type of some scholarly work by somebody else. And why is that important? Because given that this Daubert is an exercise in avoiding because I say so type stuff, the more you can show that what your expert is saying is there are other people on the same bandwagon, okay, the better off you're going to be. And how do you do that? Well, you go out and you get journals, you get scholarly works. I definitely do not want to leave this podcast or whatever the heck you call it. This is my first webinar, so I don't even know what to call them. But I'm going to give you a resource that I use, and I'm going to try to screen share this thing. And hopefully everybody can see this, but can everybody see my computer screen here? Okay, I'm assuming the answer to that's yes. So I'm going to type in Google. This is a Google search. I'm going to type in scholar, okay? And what comes up is a thing called Google Scholar. I guarantee you that there isn't a scholarly or scientific paper on medicine, engineering, or any other scientific field that you can't find on Google Scholar. And you can get, I'm just going to pick a random subject out of thin air here. How about a medical issue? How about adjacent segment disease, okay? You click on that, and every single paper that's ever been published on that particular scientific topic is there, okay? And you can do time ranges, okay? You can do all time. You can create your own custom range. And, if you want to know what the latest articles are, like you put in 2021, and a lot of these things you can get, they're available for free by PDF. Some of them aren't, and you can click on the abstract, and if this one will come up, and you can go, it'll tell you how to buy it, okay? And you just whip your credit card out and buy the thing, okay? Let's try some other. Let's see if I can find some other topic. How about for you criminal lawyers? How about blood alcohol content? How about that? Concentration. I'll just pick one of these topics. And you click, and here's all the stuff. If you want recent stuff, you can find it. If you want to search by author, you can do it. But I'm just here to tell you, I spend half of my life on Google Scholar because I'm trying to come up with research to feed to my experts to support, to footnote their reports when there are reports, and even if there aren't, to make it clear to the reviewing judge that what my expert has got to say is he or she's not out on an isolated island somewhere. She's in the mainstream, and that is a big help to establishing that whatever your expert is saying is based on a reliable methodology. Google Scholar.
Mike, yeah. We have a few questions here. Can I jump in with a few questions?
Yeah, sure, absolutely.
Okay, question from Greg. In cases where an expert bases their opinion on various federal regulations, codes, etc., how do you work with the expert to present their opinions that doesn't get them into trouble? The reason I ask is that unfortunately, at least in the Fifth Circuit, there is a case law decision where a judge excludes certain opinions as to violations of regulations, holding it wouldn't be helpful to a jury because it usurps the judge's role to tell them what the law is.
Okay, well that's unfortunate, but that describes that judge that I mentioned a minute ago. The one that doesn't believe that experts have a place in garden variety personal injury cases, at least on liability. He'll let medical experts testify. I mean, that issue has been fully litigated in the 11th Circuit, all the way up to the 11th Circuit. And keep in mind that the 11th Circuit in 1980, split off from the Fifth Circuit. The Fifth Circuit case law at that point was pretty well developed that it's an abuse of discretion and reversible error to not let an expert publish non-binding voluntary industry safety standards and then explain why they weren't complied with at the location of whatever incident. And I'm happy, I don't have the time to share that with you, but if you email me, whoever, is it Greg? I'm happy to give that. I'll give you the Fifth Circuit case law. And I'm surprised that it's changed because the 11th Circuit has based its rulings that stuff comes in based off of what went on in the Fifth Circuit before the 11th Circuit got formed. So yeah, I hope that answers the question.
Okay, I got another great question here from Greg. This is a quasi-Daubert question mixed with procedure. Like you pointed out, in almost every case, there is a Daubert motion as well as an FRCP 56 summary judgment motion. Most of the time, the expert sets forth their qualifications in their Rule 26 report. There's case law in certain jurisdictions that says the expert report is hearsay. So in terms of meeting the shifted burden to establish qualifications / methodology, do you attach an affidavit with the report, or do you put on a brief exam during the expert's deposition, which some lawyers dislike because they feel it's tipping their trial direct hat? What would you recommend, Mike?
Well, I do both, and I do both in just about every case, because I mean, it's fun to spring surprises in the trial, but you got to get your expert to trial. So you got to take care of the first order of business, and so I do both of those things. I basically, the first part of the question was about the report. I'll usually, if there's a Daubert motion, I'll file the expert's deposition and I'll file the report separately. You're right that some places say that the report is hearsay. So what I'll do is I'll at least go out and get a short affidavit from the expert making the report an exhibit, and have the expert say in the short affidavit, I'm adopting everything that I said in my report under oath as if I was testifying in trial. Okay, that's enough I think to solve the hearsay problem with the report. Although I'm not confident that if the report is discussed by the expert on the record in the expert's deposition, and it's a federal case at least, then it's not hearsay. Okay, because the expert is there, quote, in the equivalent of open court to answer questions about the report. But I do all those things. And in addition to that, sometimes, most of the time, I'll go out and get a detailed affidavit that will kind of I'll take the draft of the report if I have one and break it down into affidavit form, and then add at the bottom any specific rebuttal that the expert needs to be made in light of the Daubert motion. And let me just, I hope that answers the question. And by the way, if you do the affidavit, well, I don't want to get into that. I'm getting too far in the weeds, and I don't want to do that for purposes of, but if you have more of that question, please give me a call on my cell phone. I'll try to answer it for you. Let me talk about in federal court, and this is partially in response to that last question. Daubert motions are decided by the court, not the jury. We all know that. And in federal court, those decisions about admissibility of expert and other types of evidence are made under Federal Rule 104A. Okay, what that rule basically, there's no corresponding state rule here in Florida, which is a problem. It's another reason why Daubert is not a very good fit for state court, at least here in Florida. But the Federal Rule 104A says that the court must decide preliminary questions about whether a witness is qualified or evidence is admissible. In so deciding, the court is not bound by the evidence rules except those on privilege. Now, what does that mean? It means, at least in my experience in the Southern District of Florida, you can just bombard the federal judge with all kinds of supplemental stuff, medical journals, affidavits from the expert, anything you want. Basically, it doesn't have to necessarily, it can be hearsay. But you can bombard the federal judge and fill the record with all this stuff I'm talking about. Now, do I do that? No, I bombard the judge, but typically everything I submit is either an exhibit to a deposition or an affidavit. And keep in mind, you may end up with a Daubert hearing. That's another thing. Probably 80% of the time in the Southern District, there's no hearing and the decision is made on the papers. But the other, 20% of the time, you've got a hearing where you got to bring your expert in. And that's, that you have to be ready for all of those contingencies. Let me talk. I really don't want to get into this a lot because it's really specific to Florida. And I know most of the people out there are not from Florida, but there is no state court equivalent in Florida to Federal Rule 104A. In fact, unlike federal court, where a learned treatise can be read by your own expert in direct examination, the Florida rule is that you can't do that you can use a treatise in cross-examination, but only if the expert agrees that it's authoritative or you have some extra, independent source of authoritativeness. Now that creates a, hang on, I'm sorry, I humbly apologize. I thought I had this thing turned off. That creates a problem because in order to fill your record in state courts, you got to have evidentiary vehicles to do it, and you don't have you can't present a medical journal, for example, or an engineering journal with an expert in state court down here because that's bolstering and it's not cross-examination. So how do you get around that? Well, I would argue that we also have Florida Rule 704. I think most states have that. That basically talks about the basis of expert opinion. And it says that, the expert can rely on stuff that they typically rely on, even if it's hearsay. I would suggest that's probably as close as you're going to get in state court to Federal Rule 104A. And so you could just try to get the judge to look at this, this hearsay evidence, even if you couldn't use it in trial on anything but cross-examination. So with that, let me just.
Hey, Mike, while you're looking at that, we got another question here.
Yes, sir.
Two questions. This one comes from Larry. Do you have any advice, Mike, regarding Daubert motions in cases involving medical malpractice, hospital malpractice, or nursing home wrongdoing?
Well, I don't do medical malpractice. I've done probably 2 trials, and it's been a long time ago, and I never really got my head around them. But I've got a really good friend here in town that does nothing but, and he's a big fan of Daubert. Okay, he's a plaintiff's lawyer, and his name is Chris Lamoya. He's a really smart guy, and he loves Daubert because he loves to if nothing else, even if he loses the Daubert motion, he gets another forum to challenge the expert. And a lot of doctors are Ipsy Dixit type guys, and of all types of experts, even in a Daubert environment, the ones that can kind of get away with Ipsy Dixit because I said so, they're doctors. Judges defer to doctors all the time. I would say the more technical medical topic that there is, the more likely you can Daubert out a defense expert who really doesn't know the technical stuff. Okay, if it's a broken bone or something like that, forget about it. Judges are not going to grant a Daubert motion on that type of injury. But if it's something like a toxic tort, then we're talking about a different ballgame. The witness can be a doctor, but I'll give you. John mentioned the Dalcon shields. Okay, I'll give you an example of how stuff has changed from those days. We could bring in a gynecologist, a treating gynecologist, who could come in and say, in my opinion, the Dalcon shield caused the problem. Okay, and you get away with that. I mean, in state court and actually in federal court too. This is like 100 years ago. What that same witness is going to have to do to get past Daubert now, particularly in federal, it's almost as if they're going to have to go out and conduct original research to determine whether the Dalcon shield or whatever product you're talking about is capable of causing the injury in the first place. In other words, general causation, and that's why toxic tort cases. I mean, back in the day, we could do a pharmaceutical liability case like a Dalcon shield for $20,000. I mean, to do a toxic tort case, somebody's going to have to spend a couple of $1 million just working the bellwether case up. Probably more than that, because Daubert's a big reason. Because you gotta, you just can't have some expert come in and say because I said so. I don't know if that answers the question, but hopefully it did. All right, I don't want to short sheet anything here, but let me hit a couple of more topics. Okay, in the 11th Circuit, I mean, the propriety of submitting all these supplemental materials for Daubert purposes, the affidavits and the studies, it's recognized. And I can, somebody wants the case law, I've got an outline here. I'm happy to email to anybody. I didn't want to do a PowerPoint today because I basically don't know how to do them, but I've got that. It's okay to do that. Another thing is when you get an expert, let's just take one who's prepared a report, okay? And that report, you try to cover all the bases. You try to have in there, first off, you have to figure out, what am I going to call this person to testify to at trial? Okay, what is the core of that person's testimony going to be? And then that has to be addressed in the report for a jurisdiction like federal court that requires one. But you can't do everything. You can't, and they get Daubert motions, and that's typically they come after the expert's deposition has been taken, and here comes all this nitpicking on a Daubert motion. There's no way that should be covered in an initial report. And so there's some case law, again, I can give it to you privately, but that the expert doesn't have to rebut the Daubert motion in the expert's report. You don't know what's coming, and typically you don't know what's coming until after the expert's deposition is taken. So some judges will, deciding Daubert motions, will say, well, if it's not in the report, then I'm not going to let that point be made in opposition to the Daubert motion. But there's some case law that says, yeah, you got to do that, because it's not fair to have the expert anticipate every single Daubert objection on methodology. They'd have to do a 5,000-page report, and that's stupid. So you're kind of okay on that if you know the right cases to cite. Okay, now I'm going to get to the topic of the talk, and I'll try to get through it very quickly. Essential times and steps to Daubert-proof your expert. I told you before that for me, that starts when I figure out whether I'm going to take the case or not, and whether it's going to be it's going to be expert heavy, and what are the expert heavy elements. And sometimes my analysis of that tells me I ain't taking that case because it's too. I've got one element critical that's sitting out there that's going to require expert testimony. And if I lose my expert on that case, I'm going to get a summary judgment, and I may just step away from the case on that basis. You got to be thinking about this stuff early in the game. What's the first thing you can do to become to Daubert-proof your expert? Well, you can become an expert on Daubert yourself. Okay. Now, again, I had to get hit in the head with a baseball bat before I figured that out. Okay. I made up my mind right then. That's never going to happen to me again. So I really went out and tried to be a scholar, somewhat on Daubert, and figure out what the hell does it really mean? What is this methodology business? Okay. What does that really mean? Helpfulness, all that stuff. A lot of times, the next point I want to make is in your relationship with your expert, okay, assuming you pick the right one, you're the dog and the expert's the tail. And that's a hard thing to get one's head around if one is a delegator who really doesn't like to get involved in the day-to-day nuts and bolts of their case. And there are a lot of people like that. Okay, now I got no problem with them. A lot of volume lawyers have that mindset. I don't blame them. I would too if I was a volume lawyer instead of a custom lawyer. But you can't just say, expert, here's this stuff like we used to send you in Fry, and go figure it out and tell me what you think. If you do that, you risk a Daubert ignorant expert screwing up your case. You got to sit there and educate. And the first thing I do when I get a new expert, I don't have to do it with my repeat experts, but with a new one, I go, let me tell you about Daubert. You ever heard of Daubert? Daubert, whatever the hell you call it. And they typically go, no. I say, well, okay, let's take 30 minutes or an hour, and I'm going to explain what this stupid Daubert thing is that you're going to have to get over, and I'm going to help you do it. Okay. So you educate your expert. Select a real expert if possible, okay? Not some all-purpose, safety guru or other generalist who hasn't had a real job in over a decade. Those people are just lightning rods for Daubert motions and adverse Daubert rulings. So you want to pick somebody that's actually in the trade. Sometimes these people are what I call virgin experts, and sometimes they're the best. The guy, the snow room guy I mentioned from the UK, he'd never been an expert before, okay, but he's a good guy, and I was able to get him up to speed on the things that repeat players in the litigation system know by heart, and he did a great job. Now, the judge hasn't ruled on the Daubert motion, but I thought he did as good a job as could be expected given the fact that he had not done an expert case before, never had a deposition taken, and he did pretty good. It was like a 10-hour deposition, but he did a great job. So you got to be prepared to spend whatever money it takes to get your expert in the best position to testify, rather than doing things on the cheap. And let me give you an example. not sending your expert out to look at the accident scene. I mean, that happens sometimes in cruise cases because, these accidents happen in Timbuktu and, Trinidad and you name the place. And, whoever gets the case just, doesn't want to send their expert out to look at doesn't want to spend the money. Federal cases, because of Daubert, and I would say primarily because you take the same case in federal court and the same case in state court, and you're going to spend 2 to 3 times as much money in federal court getting your case Daubert-proof, so you're not going to lose your expert. Just a simple fact of life, okay? And you gotta be willing to spend the money. That's going to be increasingly true in state court also, okay? It's just a matter of time. They haven't gotten to the point in state court where every expert gets Dauberted, but it's gonna get there, trust me. And so you have to be willing to spend the time and money. Insist that your expert reference this third-party literature that I keep talking about. And one way to save money, and that's why I know I spend half my life on Google Scholar. But you know why? Because I don't cost anything. Okay, I got time on my hands that I can sit here and just do word searches and come up with the articles that are relevant and most recent and on the point and feed them to the experts. And there's no harm in doing that. Just review this article. Tell me what you think about it, rather than paying an expert $300 an hour to sit there and do the same damn thing. Pretty soon you get a $20,000 bill for research time. So that's a way I try to economize on cases when I can do it. So you're entitled to submit to submit materials for your experts' consideration. The more scientific references, you have a big old long bibliography on the back of an expert report, the more the judge sees of those things, that less likely he or she is going to grant a Daubert motion on basis of inadequate methodology. Okay, I've given this, I've talked in another venue before, and I've had sample reports attached, which I'm willing to share with anybody. If you have a specific type of case, whether it be a care plan by a physiatrist or some kind of engineering issue or whatnot, I'm happy to share reports. Just email me or call me, and I'm happy to do that and talk to you about your case. Okay, reports. Federal court, you're going to have a report from any retained expert. If it's a treating physician, you're going to have a kind of I call it a report light, but it needs to be something in writing that explains if you're going to take them out of their lane into from a treatment and diagnosis into something like causation or future care, which is out of their treatment lane. You're going to have to you're making them a retained expert in a certain sense, and you're going to need a short report from the treating physician. All those things need to be prepared and submitted timely under the disclosure deadlines, or at least in federal court. You may have something similar in state court. By the way, our Supreme Court down here in Florida is basically they're trying to superimpose the federal stuff, the federal procedures and whatnot on state court. And that's fine, but our circuit judges don't have they don't have the time or the resources or the staff to process that, and they never will. So, we're going to have a logjam in state court down here for that reason. I told you that in federal court, interactions between retaining lawyers and retained experts is all privileged. The only thing that the opposition gets is a final report. In state court, we don't have that privilege down here, so you have to be careful in your interactions with an expert in state court, so you're not laying a paper trail that's subject to discovery. Now, the good news is there's no expert report requirement at least in Florida state court. Not even for doctors, although most of the time CMEs and other types of doctors generate reports, but there's no requirement that they do so. Plus, as I said before, doctors are better writers and engineers and other types of liability experts. Okay, let's talk about, somebody asked a question a minute ago about, what do you do in a deposition for an expert to minimize the chance they're going to get Dauberted? Well, in the preparation phase, the first thing I tell an expert is, look, you never, unless it's true, admit that you're not an expert on anything, okay? The minute you say, I'm not an expert on adjacent segment disease, or I'm not an expert on whatever the topic is, or the subtopic, they're not going to be allowed to testify, Okay, an admission by an expert that they're, quote, not an expert, end quote, is fatal. So you try to, and they go, well, how do I answer that? Well, you're so technically trained, you can probably truthfully say and answer to most questions, I know more than the average person, okay, which is, kind of the definition of an expert. It's a loose definition of an expert, but never let them admit that they are not an expert on some topic, otherwise their history. You make sure they avoid terms like speculation. Well, you're just speculating, aren't you? Well, kind of, yeah. Or you're assuming something. I just another expert from another jurisdiction who used the word presume or assume. Those are bad words. Okay, they demonstrate a lack of knowledge of the subject, and they demonstrate a lack of reliability in their conclusions. So somebody asked, what do you do? What do you do, if anything, in the opposition's deposition of your expert? I conduct pretty much a direct exam, okay, at the end. And my experts, some of them, there's one doctor I'm thinking of that happens in a lot of my cases. He gets pissed, and it's usually late at night. I'm going, dude, you want to get Dauberted or not? So I sit there and cover the qualifications, have him go through and explain, his stepwise formula to get to his conclusion, so he's not just showing the work and not just putting the answer up on the board, and try to have him explain why it's going to help a jury, why it's a technical topic that is mostly just known to a doctor or mostly just known to an engineer. All that stuff's on the record, and I'll take a lot of time doing that. When it comes to using medical journals in a deposition of my expert, I bring them and I make them all exhibits to the deposition. I'm okay if there are like 15 medical journals or 15 engineering journals that are topical that are attached as exhibits to the deposition. I always try to attach the expert's report to the deposition, and I get them to say, in lieu of an affidavit, that I'm adopting under oath my report, okay, as if I was testifying to each and every topic in the report under oath today or at trial. And that, if there's any kind of hearsay problem with the report, which I don't believe should be, that solves it. Okay, let's talk about opposing experts just for a minute. A lot of times, I get what's the rule of thumb by defense lawyers, opposition lawyers, is if the plaintiff gets an expert, they got to CYA and get their own expert of the same type. And so, when you get into the opposition expert's deposition, try to get them to endorse the formula and the methodology that was followed by your expert. It's going to make it, if they say yes, take a doctor, a CME doctor. What did you do? Well, I did an examination, just like the one that my doctor did. Yeah. I did reviewed medical records, just like the plaintiff's expert. I took X-rays, just like the plaintiff's expert. I looked at the imaging, just like the plaintiff's expert. In other words, you guys reached different conclusions, but you used the same formula. And by the way, doctor, different physicians can disagree about the same patient. Yeah, that's true. Daubert has no unanimity requirement. Okay, that's very important to realize. All the doctors on your side of the case, experts versus treating physicians, they can be at odds with each other on conclusions and sub-conclusions and everything else. It's not the conclusion that counts. Okay, the judges are not supposed to, under Daubert, look at the conclusion and go, oh, that seems fishy to me, I disagree with it. It's the process that counts, the methodology, the stepwise process. And you have to, I'll give you an example. Best example I can think of with a medical causation. There's some literature out there, which I use all the time. I attach to my medical experts' depositions. It has a stepwise three-step approach to determining medical causation. One is, can the insult or the accident or the pill or what, can that cause this type of outcome in general? That's called general causation. Yes. Okay. And explain why. And then you attach all your medical journals that prove that. Was there a temporal relationship between this insult or accident and the onset of the symptoms? Yes or no? Okay. And what's a temporal? Well, it happened within a short amount of time, either at the time of or a reasonably short amount of time after the incident. Okay. Yes or no? And then, if we know that this insult can cause this, and there was a time relationship between the insult and the symptoms, did you consider all of the potential causes of this in this particular patient, called a differential diagnosis? And as long as they follow that and they explain why the cause you want to prove is the most plausible of several competing clauses, and they go through each of the competing clauses, that's an example of a absolutely reliable methodology to get to medical causation that has been peer reviewed, and it's out there in the literature. And I think even the defense doctors, will grudgingly admit that that's the same thing that they follow in terms of reaching a causation conclusion. Okay, I always, not always, okay, but in the case of let's take a slip and fall where you've got an engineer or a trip and fall, I always list them as fact witnesses, okay, in addition to being experts, because even if the judge, Daubert pretty much has to do with opinion testimony. And if you've got an expert that's gone out and taken photographs of the scene or taken measurements or that sort of thing, that's fact testimony, okay? It's not subject to Daubert, and I always list them as fact witnesses, anticipating that the judge may knock out some of their opinions, but I can bring them into, if nothing else, to put up the pictures to show the jury what the scene looked like, or what they can describe their measurements. They may not be able to get to conclusions based on the measurements, but they can describe that. Okay. Another couple of pointers on Daubert. When you're defending your expert, you want to lower the Daubert bar as low as you can, okay? And there are ways to, there are low bar Daubert cases out there if you look hard enough for them, just like there are high bar Daubert cases that you want to use when you're trying to strike the other side's experts. And it seems a little disingenuous, but that's just the way the game is played. I've got some briefs, and so I guarantee you I've found all of the low bar cases. For example, until fairly recently, an expert had to be extremely qualified. Now, at least down in the Southern District of Florida, there's a lot of case law starting to say that they only have to be minimally qualified. So you need to be on top of another thing is that as long as the expert follows a reliable methodology, they go out and they check the right boxes and they do the stepwise formula. Most of the remaining types of objections that they would make, like, well, they didn't go visit the accident scene, or they didn't examine the patient, they just rendered an opinion off of medical records. All that stuff goes to weight and not to admissibility. And I've got another thing I can send anybody that's interested in on weight, what types of Daubert challenges have been determined to be basically weight and not admissibility, and have been denied for that reason and referred to the jury. So, be ready to make that argument if you're defending an expert. Courts, they're not allowed to evaluate the credibility of opposing experts. Standard of proof. Nothing under Rule 702 or Daubert requires that the expert resolve an ultimate issue to a reasonable scientific certainty or a medical certainty. Okay, those are, in federal court, an expert can testify and get testimony and opinions admitted if they're, at least down here, if they're just based on medical possibility, not even probability. But again, there's some other cases that are out there that talk about medical certainty, which is a jury instruction issue. It's not an expert opinion issue, and you want to lower the bar on the standard of proof. And I can help you do that if you want to give me a call. Now, I think that's it. There's a lot more. It could go into a lot more.
We have another question here. If I can jump in with this question.
Yeah.
Here it is. This is from Greg. In cases where experts are reviewing and relying on other experts' opinions as part of their report or opinion, do you have any recommendations as to the proper wording and way to go about that in a report that satisfies Federal Rule of Evidence 702, so that they are not seen as simply being a mouthpiece parroting the other expert's opinion?
Well, that's a great question, and you definitely don't want them to be just be mouthpieces. But let me just read you some language, and I can send this to anybody that wants it. But the Daubert opinion itself, that was a kind of a toxic tort type of, high-tech medical causation issue type of case. And that, but the court in Daubert said, and I quote, "An expert is permitted wide latitude to offer opinions, including those that are not based on firsthand knowledge or observation." That's Daubert. There's another Supreme Court case called Joyner, GE versus Joyner, that says specifically expert testimony that relies upon reports or data generated by others is routinely admissible. I think he's talking about a situation where you've got one expert in a case relying on the work product of another expert. And I don't have a pat answer for that. I think if let's give you, for instance, if expert one goes out and takes some measurements at the accident scene, or does some slip resistance testing, or something like that, or create some photographs or videos, that type of thing. And that the first expert is able and willing to authenticate that. I think that's probably something the expert number two can rely on. Now, the expert number two's got to do something different. Okay, they can't be duplicate experts. But in terms of creating the facts that are necessary for expert number two, I think expert number one can do that up to a point. But there has to be division of labor between the two experts. I'm not sure if that answers the question, but by the same token, I think that if it's equally clear that you just got one expert saying "me too" to another one, that's not going to fly. Hope that answered the question. So, hello.
I think you're on mute, John.
That's like a death. That's like a death sentence for John Romano.
Yeah, no, I'm trying to, there we go. Now I can see. I had the screen up there that had the questions on it. Well, Mike, this has been fabulous. And I loved all the great questions that came in. And I hope you'll do a part 2 and a part 3 and a part 4. One of the things that I thought would be helpful in the future would be a sample direct and cross of experts to show how to affirmatively take on a Daubert motion, and the other is to defend against the Daubert motion being raised against you. And then finally, a mock hearing where we have someone play the role of a judge who is a feisty, coming at you hard kind of a judge in these motions, because it seems like we're going to see a lot more of them in the future. We know that there have been a lot of judicial appointments in recent years, shall I say, where I expect defense lawyers are going to be filing more. So with that in mind, I hope we can do more of these because it's such an important issue.
Can I make one more point? I wrote it down.
Yeah, sure.
The person from the expert witness organization was talking about, I think they may try to screen their experts for prior adverse Daubert decisions. There's some case law that, and I've had to cite it a couple of times, where courts have generally said that in one case, like in a trial of one case, you can't bring up that an expert has been previously Dauberted in another case. Okay, that's because that kind of usurps the discretion and decision making by the judge in the case in question. Okay, in the case where the latest case where the expert's actually testifying. So there is some law out there on that point. And again, I'm happy to share it with anybody that is interested.
That is key. And I was not aware of that. I think that is really important. Well, Mike, again, thank you. And this has been great. I already see we're getting some wonderful comments coming back. Thank you for preparing so well and just being so knowledgeable of this subject. And Ginger, with that, we will turn it back to you.
Absolutely. I have a couple of really great announcements real quick. And we're bringing Ted in just a moment because he's going to do the coffee giveaway. But before I do that, I want to share my screen real quick and let you guys know that you can absolutely reach out to Mike Call him on his cell phone. You can also email Mike as well, including John. And then also, again, I want to thank HMR with Richard so much for joining us today, as well as Don, who popped in on behalf of Kim for On Point. But we love working with them. I am going to email this to you guys in just a little bit as well. And then I know we had a lot of questions, Mike, where everyone would love to have a copy of your outline from today. So I'll work with you on that. But in the meantime, if someone would like a copy of Mike's like briefs or summary reports or anything, please just send him an email and reach out to him. And then I'm smiling because I did tell you, Mike and John, that I was going to tell you this little story, right? Well, I get the best messages from everybody watching all day long. And a lot of them are actually good friends of yours. One of them in particular is named Jack Zimmerman. Are you familiar with him?
Oh, yes. Oh, yes.
He told me a little story today. He says the reason why that John and Mike.
It is not true.
Yeah.
He said the reason why John and Mike are so successful is that they learned how to try cases for real back in the late 1970s at Marine Corps Base Camp Lejeune, North Carolina. He says, where they were prosecutors in the office that I supervised. I was no better than they were, but I was a senior in rank, and that is why I was in charge. We are all very close. He said, John and Mike are two of the best prosecutors. They're smart, they're honest, they're dedicated, not very good looking, but otherwise okay. Give them my best. Anyway, wow. These just stories just warm my heart. I love the fact that we could bring both of you together. I'm very excited about part 2, 3, and 4. So stay tuned. We'll be getting those dates set. And Mike, I hope you will join us for those.
Okay.
We had a good time.
I may be out of steam here. I don't.
No, there's a lot to talk about. Like I said, John said this is a hot topic, and a lot of people, they're working on this right now. So again, big thanks to all of our viewers. And also I wanted to let you guys know that our next webinar is going to be on Wednesday. So be sure to go to connectionology.com to sign up for this great webinar. I'm very excited, John, to have you back on this. And then I have a new webinar that I'm actually launching next Thursday as well. So stay tuned for that. And then with all ado, I am very excited that we have Ted back with us because he's going to go ahead and announce the winner of 4 bags of this freshly roasted coffee. I mean, guys, this is an amazing gift. It smells so good. Ted, thank you for joining us today, and let us know who's the grand winner.
Welcome. So David Wells out of North Kansas City, Missouri is the big winner today of the 4 bags of Peruvian coffee. So congratulations.
Wow. Congratulations, David. All right. Well, we will definitely, Ted, reach out to him in just a few moments. Make sure that he gets his fresh coffee. And don't worry, guys, there's more chances to win, right, Ted?
Always is more chances. Yep.
Well, thank you so much for being with us. And again, big thanks to HMR. You guys are incredible. Not only do you work with us on all of these webinars, but you guys are like our grand sponsor for our next live seminar that we're going to be doing in Nashville, April 30th through May 3rd. We're going to be at the West End, and we're going to be doing a big traumatic brain injury seminar. There's 30 speakers. There's like, oh gosh, I've lost track of how many different topics, but you have the opportunity to get up to 30 CLE credits. We're going to do a live TBI mock trial. We're going to be doing fireside chat with all the speakers. We've got a great welcome reception for networking, and it's one you don't want to miss. So this is going to be a lot of fun, right, John?
It'll be great. It's going to be an awesome seminar, TBI. It'll be just terrific. But thank you all, and thank you again, Ginger, for all you do. This has just been great. And everyone, be safe, be careful, and take care.
All right. Bye, everybody. Thank you so much for joining us today. We're going to see you again next week, and we hope you have a wonderful evening. Bye, everyone.